Good afternoon, everyone. My name is David Hoffman, and I am happy to welcome you to our program today. Miranda warnings for abortion patients, disclosure and confidentiality in the era of Dobbs. I am joined by some very interesting and varied perspectives on this program, and I hope you enjoy it. I'm very sorry that we had some technical difficulties, but we're going to plow in now and we will continue on until we get through the program. So thank you for your patience. Um, First things first, I should share some legal required notices because, of course, continuing legal education credit is available for this program. And I am not able to advance the slides. So if we can go to the next slide. Thank you. First off, if you're interested in legal credit, please, of course, stay till the end. There will be 2 attendance codes that will be presented through the slide presentation, and I will also read them off as well. Next slide, please. I am really thrilled to be joined by my colleagues, Rebecca Gompert, who is from Amsterdam and is the head of the Aid Access organization that has been engaged in advocacy on behalf of women seeking abortion care for decades. Lynn Paltrow, the head of National Advocates for Pregnant Women. Dan Arshak, trial lawyer, criminal defense lawyer, counsel to National Advocates for Pregnant Women, and Jorge Rivera, who is a alumni of the Columbia Bioethics Master's Program and counsel to the New York State Senate Majority Leader for healthcare issues. I should say, as a matter of legal necessity, that the presenters have declared no conflicts of interest with regard to this program. But also, of course, that opinions expressed by the participants do not necessarily represent the positions of their institutions. Next slide, please. This is our agenda. I will give a brief introduction to the legal and ethical issues facing both clinicians and attorneys. We'll then move on to a discussion presented by Rebecca Gompert on the advocacy perspective for clinicians, and then, Lynn Paltrow on the advocacy perspectives of clinicians, and then on to Lynn Gompert for an international perspective, followed by Dan Arshak describing the ethical responsibilities of clinicians and the lawyers who advise them. Then Jorge will be presenting on legislative and policy solutions, and we'll wrap up with a free-flowing discussion among the entire panel on what we ought to be doing in order to ensure that patient confidentiality rights are both respected and protected as we move through what will clearly be a transition from our federal model of abortion privacy and access protection to a state-driven model. Next, please. So first, let me remind myself and all of us why it is we're here. Next. These are the 2 questions that we'll be confronting today in every aspect of the presentation. What are a clinician's ethical obligations when entering obstetrical information into an electronic health record for a patient seeking advice about abortion and care about abortion? And then the corollary question, should that clinician consult a lawyer? A question that, frankly, I didn't think we'd have to be asking, but now I think plainly we do. Next, please. So first, some ethical considerations for lawyers to set the context. And for clinicians in the audience, I would point out that this is important to you as well, because these are the questions that you want to be thinking about in determining whether you need to consult with a lawyer in the context of your clinical care. Next slide, please. We start with the basic notion of clinical confidentiality and medical confidentiality. So here I have as an example, New York State's section 33.13 of the public health law, which sets forth the privacy protections afforded to patients in New York. And in varying degrees that we will get into, there's something equivalent in every state in the United States and most places as well, medical confidentiality being a core ethical principle of the practice of medicine in every discipline. But of course, there are exceptions. So, for example, in New York, the law says such information about patients or clients shall not be released by the offices or its facilities to any person or agency outside of the office except as follows. And this is just the first provision, pursuant to an order of a court of record requiring disclosure, and this is the important characteristic of the New York law, upon a finding by the court that the interests of justice significantly outweigh the need for confidentiality. And of course, anytime a statute says that there has to be a finding, and especially a finding of one interest significantly outweighing another, we are confronted by the ethical obligation of advocacy. Next, please. In this regard, it's worth noting for lawyers, clinicians, and other interested parties, what rules constrain and define a lawyer's obligation. So under Rule 1.1 of the Model Rules of Professional Conduct, which are a generalized national standard, the definition of competence includes item C, a lawyer shall not intentionally fail to seek the objectives of the client through reasonably available means permitted by law and these rules. That's a restatement of the prior doctrine of zealous advocacy. And of course, it is the rule of zealous advocacy that often gets lawyers, whether on the side of the government, state health departments, and attorneys general, and prosecutors, and lawyers for people involved in the legal system, either the civil or criminal system, gets them into trouble sometimes. And that's what we want to be careful of. We should also be mindful of Rule 1.2. A lawyer may refuse to aid or participate in conduct that the lawyer believes to be unlawful. And in addition, a lawyer does not violate these rules by avoiding offensive tactics, which is to say that attorneys representing the state or individual clients have an obligation to exercise some judgment as to how they will and will not enforce the law. I'm sorry, next slide, please. I missed advancing, I apologize. So there's what I just read. And this Rule 1.2 defines the scope of discretion that a lawyer both can and should exercise in deciding how to define their duty of advocacy for a client. And this is particularly important in the context of state action, particularly where one state's law enforcement apparatus has to respond to requests for information, disclosure, a deposition by another state. Next slide, please. And finally, Rule 4.1, a misrepresentation can occur if a lawyer incorporates or affirms a statement of another person that the lawyer knows is false. So underlying all of these discussions is the core ethical obligation of every attorney to tell the truth. And this is important regardless of the context in which there is a dispute over what should and should not be disclosed. Next slide, please. Which of course brings us full circle back to 33.13 and the obligation of the court to address, with positions staked out by the opposing parties, whether there is a need that significantly outweighs the need of confidentiality. This can arise in a variety of circumstances. In fact, we did a CLE program not too long ago looking at this very concept in the context of prosecution of rape and whether the complaining witness, the victim, has to reveal their medical records. Next slide, please. So we can frame the question this way: what are the ethical responsibilities that a prosecuting attorney should consider when requesting court authorization under 33.13 to request obstetrical patient medical records? That is to say, are there limits to that notion, which still lingers, of zealous advocacy, given the discretion that the rules of professional conduct permit for lawyers to exercise their discretion? Next slide, please. Actually, 2 slides forward, please. We can't look at these questions without understanding the notion, in this case under New York law, of the right of patients to exercise control over what is done to their body, and the notion that they have a right of self-determination and patient autonomy. And of course, this is the famous quote from Justice Cardozo in Schlowendorf versus Society of New York Hospital: "Every human being of adult years and sound mind has a right to determine what shall be done with his own body." Unfortunate gender choice, because Schlowendorf was Mary Schlowendorf, and her issues were decidedly related to her female gender. So next slide. Oh, I'm sorry. No, you're good. Apologize. So what can we learn about this notion of privacy and the extent to which the courts ought to be allowed to override a patient's privacy from existing New York law? And I would point your attention in this respect to Section 4507 of the Civil Practice Law and Rules, the CPLR, which is an example of a law passed by the New York State Legislature that specifically addresses a heightened level of privacy afforded to certain kinds of clinicians, in this case, clinical psychologists. And what's interesting about 4507 is it says that for the reasons that justify this statute in the first place, the privacy right of a clinical psychologist and her or his client or patient is on the same level as the confidentiality afforded between attorney and client, which is, as a practical matter, the highest level of confidentiality that is afforded in New York State. Next slide, please. So what does 4507 have to do with abortion? Well, I would suggest to you that it is the same problem that the legislature responded to by adopting 4507 that we're currently seeing in this debate about privacy for individuals seeking abortion services, medical abortions, and particularly medical abortion services via telemedicine, which will be a theme running through our entire program today. So in the practice commentaries to 4507, Vincent Alexander noted that under CPLR 4507, privilege applies to the confidential relations and communications between psychologist and patient on the same basis as under the attorney-client privilege. Then he goes on to note, traditional interpretation of the attorney-client privilege therefore applies by analogy to the psychologist-patient privilege. The question we ought to be asking today is whether what is needed to respond to the variability in laws between states is action by New York to put the confidentiality protections that are afforded to patients seeking abortion services on the same level as psychologists, and therefore, by extension, on the same level as an attorney and their client. That's a big idea, one that we are going to be exploring later in the program. Jorge will have some comments on that, and then I'm sure there will be a vigorous discussion in our panel discussion part of the program. Next slide, please. Which, of course, brings us to Dobbs, right? It seems like we've been dealing with this forever, but the case was only first decided on June 24th, 2022, but it has taken up a lot of attention among the legal, clinical, ethical, and public policy advocacy community, and for good reason. And just to summarize the actual legal finding, next please. Here is the court's synopsis of the case from the Supreme Court decision. Sole facility providing abortion services in Mississippi, as well as one of its abortion providers, brought action against state officials responsible for overseeing healthcare and medical licensing, challenging the constitutionality of Mississippi's Gestational Age Act. The district court, the first court to hear the case, granted the facility's motion to limit discovery to issues of viability, and the Court of Appeals said, we're going to expand this to recognize this right and permanently enjoin the act in all of its applications, which is what brought the case to the U.S. Supreme Court. And of course, as we know, it was the Supreme Court's resolution of the Court of Appeals decision that resulted in the striking down of Roe versus Wade, moving this from a federal constitutional legal question to a state statutory legal question. Next slide, please. And that, of course, brings us to Miranda and the title of today's program. Now, to be clear, we're not talking about a literal application of the Miranda warning, but if you haven't thought about the Miranda warning other than the context of it's being recited on television police dramas, it's worth reviewing for us today. The Miranda warning sets forth that you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. And then, of course, the all-important question, do you understand these rights? And on the basis of your understanding, do you want to speak at all? So, next slide, please. This brings us to the question of patients and the relationship between clinicians and patients. And these two questions: should clinicians give such a warning to their patients? And should attorneys be advising their clinician clients that they need to? And while it is a clearly provocative assertion, the notion that a patient would need to be warned of their right to remain silent, in the context of this unsettled legal terrain, where some states may be seeking the medical records created in other states for use in prosecutions for violation of a state's ban on abortion, states that allow abortion rights and permit, for example, telemedicine provision of abortion care services, we need to be concerned not just about the core instance of the right of privacy, but how that notion that the right of privacy, for example, in New York under 33.13, can be overridden by a legal action of a court. And of course, the more complicated question of what happens if a non-New York court, for example, were to issue a subpoena or take other legal action to compel the disclosure of the records of a New York-based clinician who gave either advice or actual treatment, the writing of prescriptions for termination of pregnancy medications, in the context of a criminal prosecution, either of the prescribing clinician or the patient to whom the prescription was issued. And to look at this in its larger historical context, next slide, please. I am pleased to introduce Lynn Paltrow. And if we can get Lynn brought into the conversation. Lynn, hello, Lynn.
Hi.
Lynn is the Chief Executive Officer of the National Advocates for Pregnant Women organization and has for decades been directly immersed in the work of educating and advocating for individuals, including clinicians and patients, who confront issues related to law enforcement that is tied to pregnancy. And so, Lynn, I've asked you to look at the legal landscape from the perspective of advocates on behalf of clinicians. So please take it away.
Thank you so much. I have to start by broadening things, which is to say that if we're going to ask this question, it cannot be limited to Miranda warnings for abortion. It has to be a question of Miranda warnings for pregnant patients. And the reason for that is that the anti-abortion frameworks, and particularly the claim that fetuses, that fertilized eggs, embryos, and fetuses should be recognized as completely separate with their own independent rights, has been used to justify all sorts of incursions on people who are pregnant and not seeking to end their abortions. So what Dobbs did, among the things that Dobbs did, is say that any law, any health law, and when I'm representing a doctor or somebody dealing with a pregnant patient dealing with some other issue, I'll say, look, Dobbs was only about abortion. But Dobbs says that now that it has overruled Roe v. Wade, laws passed to protect unborn lives have to be reviewed at the lowest level of review, rational relationship test, and that the courts should respect legislature's findings and laws regulating it. So one example is Tennessee in 2014 passed a law treating fetal assault as a crime. Fetal assault committed by the pregnant woman herself. It was passed in the guise of responding to the opioid epidemic. It was passed with the claim that it would discourage opioid use, protect unborn lives, and lead to better health outcomes. Because there was an organized opposition, it was one of the only times I've ever seen a criminal law that had a sunset. It said it would sunset in 2 years if it didn't show if it didn't work. And the fact was that women were going to jail, not just for using opioids, but for using any criminalized drugs. And I would think it did go out of effect in 2016 because the evidence of counterproductive impact, deterring women from coming for healthcare, women crossing state lines to give birth, women giving birth in cars to avoid being discovered as having used any drug for any amount of time, was counterproductive. And there's been some research documenting harm to fetuses and increased risk of actual stillbirth and fetal death because of those laws. All of that would have to be ignored after Dobbs. So that any law that was passed regulating pregnant patients, not just outlawing abortion, would likely, under the Supreme Court's interpretation, its ruling, would have to be upheld. So it's not just abortion. Confidentiality, what we heard about, I'm curious as to what will happen. The decision in Dobbs also described what that decision is different from every other decision that rests on privacy because potential life is unique. Protecting potential life is unique because abortion, unlike anything else, involves destroying potential life. What's clear is pregnancy itself is unique. The people, according to the decision, who get pregnant are unique. And they are leaving to the states the determination of how that fetal life will be valued, will be protected under state law. If states do pass laws declaring independent, full constitutional rights, and some states already have, for the unborn, I question whether the people who get pregnant have any right to confidentiality. How will they be judged? Because at the moment they carry a fertilized egg, there are two patients, and the argument, at least outside of New York and probably in some parts of New York, will be that the state is entitled through its child welfare, its its parents' patriae authority to get those records. So I think there are a lot of assumptions that we have to question post-Dobbs. Also, Miranda warning, as you heard in this title, is not the exact explicit Miranda warning, but it is the idea of what should patients be told and warned about. I do want to raise the question of whether Miranda warnings work for people who are arrested. There is recently a wonderful webinar sponsored by the Movement for Family Power, talking about how in the civil child welfare system, all sorts of searches occur without protection of the Fourth Amendment, without Miranda warnings. But the fact is, how helpful are Miranda warnings even in the criminal context? And it's not that I want to discourage those warnings or question their importance, but really to get at what is it that we need to do to protect everyone, including those who are pregnant. Informed consent, an ethical obligation, as well as legal, is one that should occur and often doesn't in many medical contexts. And it should include the social and legal consequences of what somebody is doing. New York law, an example of a situation in which it's not just about abortion, is the Renate case in New York. Renate is a Hasidic woman who had had 2 previous births by cesarean. She was pregnant again. She wanted to have many pregnancies. And she realized that her earlier cesareans were probably unnecessary and the recovery from them very difficult. She thought she had worked very hard to find doctors who respected her decision to have a trial of labor, to try to deliver vaginally and to not presume immediately that a cesarean was necessary. She went to Staten Island University Hospital. Her doctor was not on call. Somebody else came in, saw she had 2 previous cesareans and said, "You have to have a C-section right now." And she said, "Look, you're not giving me any information that suggests that I can't keep trying, at least for a period of time." They wheeled her in, cut her open, caused damage to her bladder. And she has been fighting ever since. It has been 11 years of a lawsuit. It was a case in which the doctor wrote in the patient's record, "The patient has decisional capacity. We are overriding it." It turned out the hospital had a secret, not disclosed to the patient policy that purported to authorize doctors to perform surgery on patients who did not consent if it posed certain kinds of risk in their perception to the fetus, and to do so without seeking any kind of court order. And part of the reason that she has yet to win any legal proceeding is the argument by the hospital that her refusal of a cesarean was the same, would have resulted in fetal death and would have been the same as an illegal and at the time criminal late-term abortion. So this is how these things play out. They don't stay captured to just the decision about abortion. So what we know is that the cases that National Advocates for Pregnant Women has documented, hundreds, and now more than nearly 2,000 cases of arrests and equivalents of pregnant women. In about 27% of those cases of our first study, looking at cases from 1973 to 2005, 27% of those cases came to police attention because healthcare providers or people in the healthcare setting turned their patients in. A report by If When How looked just at cases involving abortion, and they said 1/3 of those resulted from hospital staff turning in their patients. And so in talks to the medical community, it's very important to have them understand what they are exposing their patients to. And I suspect they do not tell them, if you disclose something to us about your intention, why you're doing what you're doing, we will share that information with the police. I think I've been asked to talk about several examples of this more specifically, and they range from the most egregious or the most intensive less so. So in a case I worked on for many years, Ferguson v. City of Charleston, the Medical University of South Carolina had staff, a white nurse who believed she was seeing a problem of cocaine use among her primarily Black pregnant patient base, heard about women in the upstate being arrested for being pregnant and using crack, the smokable form of cocaine, and went to the hospital's lawyer and said, hey, they're arresting them in the upstate, why can't we? And the lawyer, instead of saying, we're a hospital, we should look at what healthcare we have available, which was zero for pregnant drug using or pregnant actually dependent, drug dependent women. He said, what a great idea. And the hospital's lawyer, the hospital medical staff, police and prosecutors came together around a table and came up with a policy of secretly searching pregnant women for evidence of drug use and turning it over to the police, facilitating the transfer of confidential information and assisting in having them taken out literally in chains and shackles from having just given birth, or in some cases while they were still pregnant. The case is often talked about as illegal drug testing. The drug testing they agreed to for medical purposes, but not not as a search for the collection of criminal information. Somehow, miraculously, the case went to the Supreme Court. We actually won 6-3, that these constituted illegal searches. And it was a state hospital. The staff that participated in this had actual liability for their violation of Fourth Amendment rights. If you look at who voted in that case, I don't think if the same case came back to the court, it would have a majority, much less 6-3. And interestingly, in the oral argument of Dobbs, Justice Thomas did not ask any questions of the side challenging the law about abortion. Instead, he brought up his understanding of that case, and I think similar ones that he was imagining, and said women are allowed to be arrested for unborn child neglect after viability. Talk to me about whether we could now, if we overrule Roe, essentially, be able to arrest them at all stages of pregnancy. So that was exactly what was on his mind. Another case from Texas. In Texas, the state in 2003 passed a fetal homicide law, which made it a crime if somebody else caused a pregnant woman to lose a pregnancy, attacked her, harmed her. And they called it the Prenatal Protection Act. And it was described as something that would protect the health and well-being of pregnant women and their unborn children. It would create a wall of protection around pregnant women and their unborn children. Within 3 weeks of passing that law, a law that I would argue Dobbs has now liberated every state to pass and to go further and say fetuses have full legal protections. Within 3 weeks of that law passing, a prosecutor in Potter County sent a letter to all physicians saying it is now a legal requirement for you to report pregnant women who are using illegal narcotics. Doctors did not say, wait a minute, that violates our ethical obligations. It conflicts with other requirements of confidentiality under state law. And rather than investigate the legality of this letter or the legal foundation for this letter, or refuse to participate in turning their patients over to the police, more than 50 women were reported, arrested, and incarcerated until we were able to challenge it and get that interpretation of the law overturned. But many women were in jail, including the named plaintiff, who was a Black woman who apparently had a pretty severe developmental disability, who was left to the streets of Texas. And I say this because it's an example of the claim that, every pregnant person is supported, the mythology promoted in Dobbs. She talked about her rape babies. She had a number of children, and there were many that were the result of rape. And part of the argument for why she deserved to be prosecuted under this interpretation of the Unborn Child Protection Act was that she failed to accept offers of getting sterilized. She was an example of the extreme lack of care for people and support for people, and instead the misuse not only of the criminal law, but of a denial of any kind of protection, respect, and dignity in the healthcare setting. And the other example that brings us to the specific name and title of this talk is Kenlesia Jones. Kenlesia Jones, at 5 months of pregnancy, was being taken to the hospital. She delivered a baby who survived briefly, but did not make it, was not viable. The suspicion was that she had used abortion medication to have that, to end her pregnancy. Hospital staff reported her to Georgia police, and she was arrested for murder and also charged with possession of a dangerous drug, that dangerous drug being misoprostol, which I'm sure you'll be hearing more about. Fortunately, the district attorney there was aware of the law. This is before Dobbs, and rightfully said, actually, murder, you can't arrest a woman for murder, for having an abortion, for causing the death of her fetus. But she had spent 3 days in jail, taken right out of the hospital, and lived for at least a year or two with the possession for a dangerous drug, which eventually was dropped, for quite a long time. A local doctor who was not even at that hospital, on her behalf, filed a HIPAA complaint, the Health Insurance Portability and Accountability Act. I think many people think the P in HIPAA is privacy. It's not, it's portability, about the hospital staff turning her over to the police. So what is very important to understand is that for now, while Ferguson v. City of Charleston is still the law, physicians, and clearly physicians at public hospitals, I think there are arguments to be made for even those at private, do have to be aware of the Fourth Amendment rights of their patients, not to be subject to illegal searches and seizures, not to use medicine to do criminal searches, to do policing in the guise of medical care, and they can be financially liable for violation of patients' constitutional rights. But since I don't think any of us expect that to be the actual environment, legal environment we're in, it's important to talk to doctors and be available to advise them about what it is they can do and should do. Katie Watson in the New England Journal of Medicine has a terrific article about supporting, not reporting emergency department ethics in a post-Roe era, and advises, obviously everyone needs to know what their own state law is. And the ideal statement she recommends is to say, you are safe here, and my only concern is your health. The medical care you need is the same whether you've had a spontaneous miscarriage or you took pills to end your pregnancy. I only need information like your current physical symptoms and your medical history to take care of you. And this information remains confidential. And her paper is specifically about medication abortion, ending a pregnancy, protecting the health and safety and privacy of patients. But this should be applied to all pregnant patients, whether they're seeking to end a pregnancy or not. And some of you may have seen a recent New York Times article about what is abortion after Dobbs and what is even the meaning of abortion. And that becomes a big question for doctors who are dealing with ectopic pregnancies or inevitable demise pregnancies. Is removing the fetus, the embryo or fetus, an abortion? But the paper reported that anti-abortion people argue that it's very clear what an abortion is. An abortion is intention. You intend to terminate a pregnancy. The problem with that is, how do you determine intention? And how do you determine intention? who gets to have that, to make that decision. And I have just two examples there. One is, again, a case in which a woman was forced to have cesarean surgery. She was laboring at home. A hospital knew about it. In Florida, they got a court order, literally sent a sheriff to her house, took her into custody, put her in the back of an ambulance, strapped her legs together while she was in active labor, took her to the hospital where she was allowed to represent herself while a judge ruled that the state could force her to have cesarean surgery. When I got to know her afterwards, and I explained that part of the justification for that cesarean was the same argument that is used to justify abortion prohibitions, abortion limitations. She kept saying, no, it couldn't be that. She herself was profoundly opposed, is profoundly opposed to abortion. She thinks it's murder of a child. And I said, I respect that view. I understand that. But the reasoning in your case was that your decision to refuse a cesarean was no different than having a late-term abortion. And she just kept saying, no, that can't be true, and that can't be true. And I just said, why? Why do you think that can't be true? She said, because I did not intend to kill my baby. And what became clear to me in that moment is once the state gets to decide what your intent is. And the court in her case talked about her intent was bravado. Her belief that she could deliver vaginally was bravado, and a sort of selfish intention that didn't take into account fetal life. Didn't matter what she really intended. And the interesting thing about the Kenlesia Jones case and a case out of Arkansas and Bynum is the assumption was that they were trying to terminate a pregnancy, two different women. And in Kenlesia Jones' case, as she herself began to talk about it, the story is very complicated. In fact, the way she has described it is she already had two children. She couldn't get a job. She couldn't get a job because she was pregnant and showing. She wanted to deliver a baby prematurely, and many people are under the impression that every premature baby can be saved. So she was really not trying to terminate the fetus. She was trying to end the pregnancy so she could get employment to support her family. So it becomes very significant whether we entrust the state to make the decisions about intention, and as you heard from the introduction, what will be in the medical records that might be able to be used to further a prosecution, so that we have to find ways, I hope, or we have to find ways rather, of advising doctors to ensure as much privacy, as much confidentiality, as much protection as they possibly can. And to consider, as every person before Roe had to, the people having the abortions, the people who helped them, to what extent they are willing to engage in what might be civil disobedience, and what lawyering are any of the people who are watching this willing to do to defend and support the people willing to stand up for the dignity and human rights of everybody, including those who get pregnant. Thank you.
Lynn, that was terrific. And yes, we will be revisiting this question of reckless disregard for a fetus as being the equivalent of intent in our panel discussion. I specifically really want to have a discussion about the relationship between personhood rights and parenthood rights. In the context of your comment about all of the really fascinating cases, some of which I had not heard of, at least not by name, the notion that we should be elevating the confidentiality rights of pregnant people to the level of attorney and client, we should remind the non-attorney members of our audience that an attorney does not own the attorney-client privilege. The client does, right? The privilege is a privilege for the client. It is a burden, a responsibility for the attorney. And I think the cases that you have cited make the point that it ought to be the same way for pregnant individuals in the context of this very shifting landscape. So thank you very much. Next, we are going to turn, next slide, please, to Rebecca Gompert, who is the head of Aid Access. in the past having led some other really remarkable organizations that gave rise to aid access. And what I've asked Rebecca to talk about is this issue. What can New York and the US learn from her efforts to advocate on behalf of pregnant women and their clinicians around the world over the course of decades in a variety of modalities? And by the way, if you have questions about anything I've said or Lynn has said or the speakers that will follow, Rebecca, Dan, and Jorge, please put them in the chat. We'll get to all of them if we can during our panel discussion. But right now, I would like to welcome with tremendous gratitude, Dr. Rebecca Gompertz.
Thank you so much, Dan. So thank you so much for inviting me. I have a slideshow to show. So the perspective from where I will talk is actually more also about where we would like to go. And I will address some legal issues as well. Can I have the next slide? First of all, I just want to say that the US is the only country that's going way back at this moment. It's not in step what's happening with the rest of the world. This is the laws in 2014, and especially pay attention to South Korea, Argentina, Mexico, Ireland, and some other places, and Thailand. Can I have the next slide? And then you can see that abortion was legalized in these cases, also in Colombia, and that the US is now, it's a state decision now. Can I have the next slide? So just a very basic medical information. Medical abortions can be done in 3 ways or 2 ways. One is with surgical, which requires somebody who has some knowledge from the anatomy of the woman, or with abortion pills. And the abortion pills are actually really a revolution, because it means that you just need access to the pills. You don't need anything else besides the information about how to use it. It's extremely safe. Women can do it themselves at home. And there's 2 medications that either work in a combination or misoprostol alone, which is quite similar. Now, what is important to realize is that misoprostol is available in every pharmacy in the US. So it can be prescribed by anybody, but any doctor can prescribe misoprostol. Mifepristone, which is known as the abortion pill, is very restricted, and it can only be prescribed or given out by somebody who has a special contract with the distributor. So that's the one that is restricted. Can I have the next slide? So the safety of abortion, and that's with both the combination and the misoprostol alone, is as safe as common over-the-counter painkillers or medication. So it's a very, very safe medication, and more people are dying from painkillers or other things. But still, it's very controlled. Can I have the next one? So if you look at the compared safety, for example, of an early medical abortion with giving birth is 60 times more dangerous in the United States, because the United States has a very high level of maternal mortality because of the lack of healthcare to pregnant women. And a medical abortion, the risk of death is less than 1 in 500,000. So even safer than driving a car or any other surgical intervention. Can I have the next one? So the restrictions to the abortion pills are different ones in different countries. Some countries, they refuse to register it, for example, in Hungary, in Turkey, and Japan. For example, there's also other restrictions which are financial. Women cannot afford to pay for the service, which is the case in the United States, but also in European countries like Germany and Austria. But also because of private situations, which can be domestic violence, family abuse. But also what we've seen is that, some countries are censoring websites that provide abortion services. Can I have the next one? So I will skip this one. This is actually about well, not really. Okay, so this is one of the campaigns that we did with the abortion boat. So Women on Waves is the first organization that I founded, and it started with having a boat going to international waters to help women get access to abortion pills. We've been doing that since 2001. The campaign that I'm talking about now, it was in 2004 when we went with the boat to Portugal, and there the boat was stopped by warships, so we couldn't sail in. But this created a lot of discussion. The government fell, and actually abortion was legalized because of that campaign. It was a catalyzer. But of course, we went to the courts to fight this decision to stop the boat from sailing in. So this is something that we might see happening here as well, because it might happen that some states are going to forbid women to travel to the states where abortion is legalized. And so there is a fundamental right in the human rights agreements that says that people have the right to travel and to come back to where they are from. Can I have the next slide? So our case was actually about violation of the freedom of expression, because that's another thing which is also going to happen in the US, where we already see that some of the advocates, they don't dare to talk about abortion anymore because they think that they can be charged under aiding and abetting for abortion. So, for example, many of the abortion funds that are just giving information to women where to travel, they stopped because they're really scared that they could be charged under the aiding and abetting charges. This is but actually it's protected under the freedom of expression. And so we won this case for the European Court of Human Rights, where they said that with the boat, by blocking the boat with warships, that the freedom of expression was violated. Can I have next one? So now a little bit about Women on Web. Women on Web was the first telemedical service, abortion service that ever existed, actually. It's there since 2005. And we are there to help women in countries where abortion is restricted legally initially. But then we realized that also in places where should be available and legally available, that we saw that there's obstacles to care. And we have documented that, because what happens is that if the women don't get to the clinics or the doctors to get abortions, these people just fall off the plate. And only when there's an alternative available, you can actually make that visible. And that is also what we're doing now with Aid Access. We're showing what is happening now in the states where abortion is being banned, because we see an enormous increase in requests. Can I have next slide? So Women on Web, when it started, of course, and this is the argumentation that you know from all the anti-abortion groups, it was like women risking their health to get an abortion through a website. And this changed actually within 8 years. The same newspaper, it's a UK newspaper, the Daily Telegraph, they reported about Women on Web saying, abortion pills, everything you need to know. And I think this is a shift that we also saw in the US, because when I started Aid Access in 2018, people were still quite critical, saying that it's not necessary, here we don't need it, there's access to abortion, etc. And now with Dobbs' decision, that totally changed, and everybody understands that telemedical abortion services are actually it will save many women from having to travel to other states or potentially being forced to continue with the pregnancy and give birth against their will because they cannot travel. Can I have the next one? So can I next one? This is scientific research, but I'll pass through that. So this is actually the World Health Organization. This was published in 2019 or 2020. The World Health Organization now also recommends that an abortion can be done by women themselves till 12 weeks of pregnancy without any need for a medical provider, a healthcare provider. And a medical abortion is very similar to a miscarriage. Women are used to deal with these kind of things in pregnancy all the time. And there's no need for anybody to take control over access to the abortion pills. There's no need for any gatekeeper. Women can do this themselves. Can I have the next one? This is the latest guidelines in 2022. The World Health Organization also recommends the option of telemedicine as an alternative to in-person interactions with a healthcare provider. But also it recommends to fully discriminate, the full discrimination of abortion. And the World Health Organization is kind of the overarching organization when it concerns any health issues, and everything they do is based on scientific research. Can I have the next one? So what we also did is the research that we used in Ireland before abortion was legalized. We already provided abortion services since 2005, and we used the publications to influence policy there. Can I have the next one? So actually, this is a campaign that we did where we used a drone to deliver abortion pills from over the borders. So the drone was operating on the. It doesn't play now. I don't know why, but that's okay. I will explain. So we are using always the different jurisdictions in order to try to help women, and then the abortion drone was using the jurisdiction. This is in from Northern Ireland, from Ireland to Northern Ireland, and there were different laws at that moment. So the drone was controlled by somebody where that was allowed to deliver the abortion pills, and the women taking the pills were at the other side of the border. Can I have the next one? And this, the availability of the abortion pills actually dominated the discussion in the politics on legalization of abortion, and it led to the fact that it could be prescribed by general practitioners. Can I have the next one? When the referendum was in 2018, 65% of the people, 67% of the people voted for legalization of abortion. Can I have the next one? So I will go quickly through the other countries in Europe. Can I have the next one? So we see obstacles to access to care also in Germany. Next one. I will go through this because it's a lot. Italy, impact of COVID-19 on lack of access to abortion services. Can I have the next one? Next one. Next one. I will skip Europe. Yeah, Netherlands, also skip it. Yeah, it's because it's too long. Can I have the next one? Yeah, more. Sorry about this. Yeah, more. Okay, so Hungary is actually interesting because in Hungary, abortion. Yes, thank you. This is it. Next slide. Abortion is legal, but they're adapting now the same tactics as the anti-abortion groups in the US, so that women now can only have an abortion after they listen to the heartbeat, and this is causing a tremendous obstacle to abortion. So we also see now a large increase from women from Hungary for Women on Web. Can I have the next one? Next one. So the challenges are for us with Women on Web. It has also been censorship. So the website is censored in Saudi Arabia. Next one. Iran, of course. Turkey. Next one. Next one. We built an app, so because the app stores are not being censored, so that women could still use the app to fill in the online consultation. Can I have the next one? But it's also censored in Spain since 2020. Can I have the next one? And so we went to the Spanish Supreme Court in order to fight this decision, which we just won 2 weeks ago, after going through all the courts that denied, that said that the ban was real. And that is something that we also have to realize. This is also something that can be used in the US, where states are going to censor websites that are helping women getting access to the abortions. Can I have next one? Next one. Okay, so the other thing is the Google ads. They are not allowed in some countries, which makes it really hard. It's not the case in the US now, but this is also that some states can require that Google doesn't show any ads anymore from abortion providers, even out of state. Can I have the next one? And this is very important because a lot of the online services are dependent on traffic to the websites. Can I have the next one? But the other thing is, even if it's not even censorship by the states, Google itself, the algorithms are totally intransparent. And for example, what we saw at some point in 2020 is that the algorithms changed and the abortion services just disappeared. We lost 90% of the traffic from aid access. And so this is another thing where there's so little transparency. It's private companies that can do whatever they want. And it's now much easier to find anti-abortion services than it is to find abortion services in many states. Can I have the next slide? So Facebook is also censoring posts, and many people are dependent on social media also to find information about safe abortion services. Can I have the next one? Next one. Another one is PayPal blocking payments. Next one. And of course, women being prosecuted. This is also what we saw in Northern Ireland when it was still illegal, when women using women on web were prosecuted. One was a woman that was also denounced by her GP, and the other woman was denounced by her flatmates that turned her in. So what we do with women on web is we always say, women, whatever you do, never say you had an abortion. If you have to go to the hospital, you just say that you had a miscarriage. It's the same, the treatment will be the same, and you can better not disclose. And so we tell people to lie to their doctors, and that's another way. I think that is another way where we can be a step ahead. And you could also say to a woman, indeed, when you see her, just don't tell me what happened. I don't want to know. Then you don't know, and then you cannot. Your records cannot be handed. It doesn't say anything, so you can't be handed over. Can I have the next one? Next one. So now going back to the United States, I started Aid Access in 2018 when we saw a lot of requests from women in the US because of, usually it were really the poor women that couldn't afford to pay the abortion services. Can I have the next one? And then I got a letter from the FDA that I had to stop providing. I found a really amazing lawyer that sued the FDA on my behalf. I lost the case, but it didn't matter because it was a way to break through this kind of fear that was imposed by this letter. Can I have the next one? And the letter was actually signed by 120 members of the Congress, all white male. Can I have the next one? So yeah, I sued back. Next one. So we are now using really Aid Access to wait one moment, sorry. Okay, sorry, these were my kids. I had to tell them to be quiet. So we're using the Aid Access now. Texas University is analyzing all the data. Can I have the next one? And so these are the women. So that's the thing. We should never forget who's beyond here. These are really people that have nothing. They're really poor. And they are already so vulnerable for other injustices. Can I have the next one? Next one. Yeah, I'm going through this. I don't think it matters. Next one. So now, since December 2021, last December, telemedicine abortion is officially legalized by the FDA. But Texas banned abortion in September of 2021. Can I have the next one? And so, next one, please. And so we immediately saw a huge increase in requests. So this is the paper that was published where we saw initially an 1100% request, and that became a little bit less, but that has still been the case. So what we see is that people that are, when you put in an abortion ban, people will find alternative services. Can I have the next one? And this is the New York Times who reported on this paper. And you can also see where people started to travel and the request for abortion services, that it's almost the same as before the ban. Can I have the next one? Now, so next one, please. So you see the spike in visitors to the website when the ban was passed. And we had in one day, we had I don't know, many more visitors on our, almost 80,000 visitors on our website. Can I have the next one? Next one. You all know this. I don't have to tell you. So I know, I probably you've seen this as well. A woman who is pregnant carpooling, saying that she has another passenger with her so that she doesn't have to pay the fine. And actually the fine was indeed waived. She didn't have to pay it. So this is the next step. Can I have the next one? Yeah. So I think that is it. Can I have the next one? Yeah. Yeah, thank you. I think that is what I want to say. This is not. Next one? Yeah. So this is the situation, right? Where Viagra is really easily available. More men are dying from using Viagra than ever will be the case with the medication abortion. And so, yeah, thanks. That's it.
Fascinating, and obviously a wake-up call for those of us in America who haven't had to deal with these issues in a wide-scale way. When we get to our discussion, I have some questions that I'm really anxious to ask you about how we can better empower clinicians to replicate what you're doing, because clearly the work you're doing from Europe is critically important, but America ought to take this responsibility on as part of our clinical obligation to all of our patients. So we can bring the slides back up, please. And we're going to turn next to Dan Arshak. Full disclosure, Dan is my former law partner, one of my dearest friends, and was a classmate of mine in our bioethics training at Columbia in 1994. So Dan, here is your task. What are the ethical responsibilities that a criminal defense lawyer should consider when advising and representing clinicians who are facing the kinds of legal issues that Rebecca described and the kinds of legal issues that you've seen in your advocacy on behalf of the National Advocates for Pregnant Women? Please take it away. Oh, you're muted. Yep, there you are.
Am I muted still?
You're
No.
good.
Great. Well, I really do want to start off by thanking you, David, for putting this together. It's a fascinating subject. Lynn Paltrow and Rebecca Gompertz are visionaries, big picture people. I'm a guy that toils in the vineyard. I represent individuals. I do it one at a time, and you know, I love listening to Lynn, who has been a pioneer in addressing these issues for the last 25 years. I started working with Lynn, I guess 6 or 7 years ago, representing individuals, women, charged with crimes all across the country in one way or another associated with being pregnant. We've had a tremendous amount of success, but as I say, it's one person at a time. Rebecca Gompert has assisted thousands and thousands of women, and she is a fearless warrior. Learn more about her and try to support the work that she does and the work that National Advocates for Pregnant Women does as well. You know, I became involved with Rebecca Gompert when she received a cease and desist letter from the FDA, and I was called in to do the kinds of things that criminal defense attorneys do. Can you give us some advice on what her criminal exposure is? And of course, you know, in my world, I'm hired and expected to be completely paranoid on behalf of my clients. I see shadows behind every door, and anything that they might do is filled with risk and the possibility of disaster. You know, the fact that I explained all those risks to and possibilities of disasters to Rebecca when the FDA came knocking, and she said, "Well, thank you very much. I'm going forward," and she has, and of course, as we know, the cease, although she did sue the FDA and she didn't win that lawsuit. The FDA did change the rules, and the work that she's doing is no longer in contravention FDA rules or policies. So at the end of the day, she lost the battle and so far has won the war. But the question that I've been asked to address is happily at the moment a theoretical one. I'm unaware of any clinicians, certainly in New York and frankly elsewhere, who have yet been outside of their own, outside of a state that has made illegal abortions or abortion services, been prosecuted or even subpoenaed for records related to services that they've rendered to a pregnant woman or even a formerly pregnant woman who came from a state that has outlawed abortions in one way or another. And by the way, I think Lynn can correct me, but I think we're up to 28 states at this point now that has jumped on the post-Dobbs bandwagon of depriving women of their right to control their own bodies. And I'm going to take the opportunity to proselytize just a little bit. Lynn started this off by saying this isn't just about pregnancy. This isn't just about abortion. It's about pregnancy. I think we ought to actually take it a step further. This is about contempt for women. Contempt for women that our country is founded on it, right? Women were chattel at the time that our Constitution, that our Supreme Court is so beloved of, they were chattel. They had no rights. They couldn't own property. They couldn't vote. It wasn't until 1920 that women finally got the right to vote. But still, the word that doesn't appear in our Constitution is woman. And of course, it's that rationale that the Dobbs decision is founded on. Another word that doesn't appear in the Constitution is abortion. And why would it appear? We thought that as the 14th Amendment guarantees, we thought that no state shall make or enforce any law which abridges the privilege or immunities of citizens, nor shall any state deprive any person. We would think that would include women, but now we're told it doesn't, of life, liberty, or property without due process of law. So if you thought that this Dobbs decision was about abortion, think again. It's about contempt for women and a move back to the way that our forefathers, our exalted forefathers, conceived of women. They were people who were supposed to have baby, cook the food, and follow the instructions of the men in their lives. So, all right, enough of my proselytizing. Let's think about in a granular way, what are the issues that a clinician faces when, for instance, a woman at let's say 7 weeks pregnant comes to New York from Alabama or Tennessee or most of the other 28 states that have criminalized the efforts of women to control their bodies, and goes to a clinician and says, I need help. And what happens to that clinician? And let's say it's an OB or someone at Planned Parenthood who is about to take a history from that person. What happens if that clinician discovers that the woman has arrived by bus or some other conveyance from one of the states that has made an effort to obtain an abortion illegal? Well, if the clinician were to come to me first I would explain that he is at least, or she is at least, in a theoretical way, walking in a minefield. Not only could the state of Alabama or Tennessee or Arkansas or Texas now reach out and make an effort to subpoena any records that he had or she had with regard to the care that this clinician was about to provide to this patient, but could very well be exposing themselves to an aiding and abetting charge, to a RICO charge, to a conspiracy charge. The list of horribles goes on and on. It hasn't happened yet. Is it going to happen? Who knows? Probably someplace, somewhere, it's going to happen. What the other danger that the clinician is facing is in those states that have passed legislation that permits the citizens of that state to sue their friends and neighbors for civil damages. I think the max now is $10,000 per claim for any behavior that supports or facilitates an abortion. There's no reason why those lawsuits, and I'm imagining that conservative organizations within those states are going to start the process of finding plaintiffs to gang together and start bringing those claims in their state and subpoenaing and civilly charging clinicians in whatever state people from their state are going to for services. And so these clinicians are looking at potential civil charges as well. Well, what's my advice to the clinician? It's hard because what I want is to say, be like Rebecca Gompert. Thumb your nose at them. If you take a hit, you take a hit. Ask yourself what's the right thing and do it. And we will protect you to the best that we can, but it might be a rough road. And what we need are brave clinicians who refuse to do something other than what they know in their hearts, in their minds, and in their morality is the right thing to do. We need brave clinicians to move forward despite the potential danger that they find themselves in. Now, maybe there's some workarounds. And this is maybe something we can talk about as a panel a little bit later. As David explained to you, the CPLR in New York State, Section 4507, has a carve out that's exclusive to psychologists, that the communications between a psychologist patient and the psychologist are treated as sacrosanct as an attorney-client communication. Now, there are some exceptions to that kind of communication as well. If an attorney and a client conspire together to commit some kind of crime, well, those kinds of communications that they have are subject to what's called the crime fraud exception, and both the attorney and the client can be prosecuted for what amounts to illegal activity engaged in by both of them. Likewise, a psychologist that engages in some sort of crime and thinks that it's going to get covered up by virtue of the sacrosanct communication that he had with his client, with whom he may have conspired to commit a crime, well, they'll be sadly mistaken. And frankly, the crime fraud exception is something that we would expect prosecutors in those very conservative states that have pass this legislation will try to rely upon in order to address the work that attorneys do with regard to both advising and engaging with clinicians and patients in states that permit abortion services. So,
but then, would it have to be a crime in the state where the clinician is practicing, where the behavior is not illegal?
so let's imagine that patient X travels from Alabama to New York and seeks the assistance of an attorney, concerned as she may well be that her behavior could expose her when she returns to Alabama, expose her to prosecution. And the attorney says, "Well, look, tell them that you had a miscarriage. Tell them this. Tell them that." That is, if that person had traveled to New York, bound and determined to rob a bank, and went to an attorney first and said, "Well, I'm going to go rob that bank. What do you think about that?" And the attorney says, "Well, listen, when you get back there, tell them you found a pile of money someplace, but don't go in there and tell them that you robbed a bank and this is how you can hide the money." Yes, the attorney could be charged with the crime fraud exception, and yes, on return to that state, having traveled for the purpose of committing that crime, that person could be charged in Alabama as well. So
the lesson being, lawyers should not lie, should not suggest illegal conduct, should not suborn perjury, and should advise clients as best they can. And I guess, Dan, the same goes for the clinicians, right? If a clinician is merely providing services.
Lawyers have no obligation to maintain records in their discussion, and frequently don't maintain records exactly for that reason. Clinicians, on the other hand, have a medical legal obligation to maintain records. And so if a patient comes to them and says, "I want help to have an abortion, I'm from Alabama," what part of that disclosure is appropriately part of the medical record?
Exactly. Right.
Right.
Yep.
So "I'm from Alabama" is not helpful to the clinician in terms of rendering whatever service they think is medically appropriate. "I want an abortion" is part and will be reported on most medical records as this is what the client says they want, and then some sort of medical observation to determine that that kind of service is necessary and that it can be done.
Okay. We'll get to this in our discussion. So wrap up and let's hear what Jorge has to suggest to make this a little more uplifting and optimistic.
Right. So let me just say this, that the quandary that we find ourselves in, that lawyers find themselves in, and that clinicians find themselves in, is solvable. But it's up to Jorge to do it. And once again, it comes down to we have to vote. And Jorge, I'm putting the responsibility right on your shoulders. We need laws that protect clinicians so that they can do what they need to do, and so that we don't extradite people from New York to Alabama to address these things, and that the records are not subpoenaable. So Jorge, take it away, man.
Thank you, Jorge.
Yes, and I'll definitely talk about that in a bit. First, I want to say thank you, David. This is a very important topic, and we've had wonderful and committed panelists. I'm glad I can be a part of this conversation. I do want to start by saying I do not represent the views of the Senate or any of its members. I just want to be very careful about that, right? And the other thing I like to start with is, more appropriately, should we really be calling these proposals rather than solutions that we've been hearing from the different stakeholders? Because sometimes, legislation might not be, sometimes it can be inadequate to tackle certain issues, as we'll see. So we just want to be mindful about that, right? And I want to have a quick civics 101 in New York State. The Senate is just one of the arms of the legislature. We also have the state assembly, and every arm in the legislature has the committees, and they see bills, get feedback. The bills eventually get passed by both houses, and they go to the executive for signing and implementation via the agency. So just keep that in mind, that it's a very long process. And there are also very different avenues to implement policy-based solutions. Sometimes, again, the legislative route might not be the most adequate. We have the executive, we have the federal government, we have regulations, we have trade groups and their rules, for example. The question is, where does it make sense to make the change in policy? And that really is determined by the problem. Do you want to go ahead with the code, or okay?
Code, the first participation code for attorneys seeking CLE credit is pregnant. I thought that would be easy to remember. And back to you, Jorge.
Thank you. And again, going back particularly to the New York Senate majority, we're a member-driven conference. So first, we have to get the members on board, of course, right? And just because there's a bill out there doesn't really mean it'll pass, or maybe in its current form, because again, politics is the art of compromise. And that's a question also to take into consideration. How is it going to look how is a bill going to look in the end? And this is why I say, again, sometimes legislation might not be the best solution to everything. And that's not a bad thing. It's just sometimes you need to manage expectations in a way, right? And the first thing we need to ask ourselves is, there has to be a problem, right? What is the problem? So for example, do our laws already cover what we're trying to do? And sometimes I ask myself, is this being purely reactionary, right? It really speaks back to the issue of understanding, what's the law of the land right now and how adequate it is in tackling the issues. And what are we actually getting done, right? And what are the unintended consequences of passing certain bills, right? And understanding, again, the process and the multiple levels involved. And the first concern in terms of this topic in particular is also being careful about not duplicating and first learning from our history, right? Not duplicating what New York did with HIV laws, for example, a couple of decades ago. Because I've heard anecdotally, information that the way the law was set up back then essentially condemned a lot of people to HIV because of the hurdles with sharing that information, right?
Exactly.
And,
yeah, we went overboard.
Right. So again, those concerns with unintended consequences. And how do we move it along with, and how does it interplay with other laws, like child abuse laws and privacy protections and certain physician or prescriber duties in the mental hygiene law, the public health law, the educational law, for example. But another concern also is, now with medical records increasingly following the patient, it'll be really difficult to avoid the effects of interoperability, right? And how do those records don't, in a sense, stay in New York because they're not physical anymore. They're going wherever the patient is going, right? And how can we use those exceptions in certain federal laws to give patients the options of whether they want to have their reproductive health information to become part of that shared health-related data among facilities, right? And that opens a whole issue of preemption, but the question and the goal is always stretching as much as we can the state's ability to deal with these issues. And, so it cannot be taken down in a court of law because we are overreaching, right? Mm-hmm. And another, the main goal then is really to make those changes that are in a way the least disruptive to care. Again, thinking about that HIV rollout, while we are achieving the most protection. Is it narrow enough to cover the creativity of hostile states? And how flexible are we going to be to current changes? Is it narrow enough to allow for evolving ethical and clinical standards, right? How can we avoid also giving hostile states and SCOTUS for that matter, material to throw back at us, right? And there are, at the end, fact patterns that we will inevitably won't see and develop over time. As Dan was saying, there are things that are theoretical at this point, but they will develop, and we'll get to see, in real time what the issues will become, right? And states are going to start to get creative, but it's also being mindful about that change, right? Something that we've heard a lot from stakeholders in this particular area is understanding and really going deep into how the information is being stored and used. Again, that interoperability that I was talking about earlier. How do we store claims information? How do we deal with transmission of medical records, or even at school records, unregulated health clinics? Anybody that has access to that kind of data, how do we capture those business associations that are tailored to those entities that have access? And that's when we get to see that a big area that is very poorly regulated is tech. And we get to see, and we're starting to see a lot in the news about third-party tracking, even in abortion sites. And how do we deal with reproductive health information on personal devices, right? And how companies are selling that information, and we're not fully aware of the extent of how that is happening right now, right? And there's really no adequate statutory, a law to avoid that, right? And in a sense, that's kind of the baseline understanding of where we're coming from. The other goal is really to build upon what we passed this year, which is a combination of semi-shield laws. You might want to think of it that way. Mm-hmm. And we're having different conversations, with several sectors to see how to strengthen those measures. Like, for example, we have exceptions to the extradition of individuals for abortion-related offenses. We also prohibit courts, county clerks, and law enforcement from cooperating with hostile states on abortion-related cases. We protected professionals from misconduct charges for providing reproductive health. We also protected them from adverse actions under medical malpractice policies. And we also expanded the state address confidentiality program to include people in the reproductive health space. And we created a cause of action for unlawful interference with protected rights. And these are not this is not the be-all, end-all, of course, right? We'll have to see what a court of law interprets, especially if it goes all the way to SCOTUS. But these are all state laws, just to keep in mind, right? Only covering what happens here, because that's we can only do so much as the state, right? Because of our system of government, there's only that much that we can do for individuals outside of New York State, unfortunately, right? But we also, not to be all doom and gloom, but we've heard possibilities like creating changes in the federal space in terms of privacy, like HIPAA, for example, and information blocking rules. In terms of here in New York, allowing domestication of maybe out-of-state orders, like allowing their domestication, but limiting or eliminating their enforcement, just to kind of go around the full faith and credit clause. But that's a very thorny issue, of course. Then building up on what we did last year, maybe prohibiting in-state subpoenas, because we really didn't envision the fact that we might have some rogue anti-abortion attorneys in the state, right? And how do we, again, deal with third-party tracking on websites? We've heard about probably reconfiguring the consent to disclosure rules in New York State, but there's always, of course, operational concerns there. Are we creating a new carve-out? How do we work? And as some of the panelists were saying before, maybe it's a question of education to directors, providers, and staff at the hospitals. Is it maybe like continuing education that they need, right? And now the topic at hand about placing reproductive health services and communications on the same basis as those provided between attorney-client, right? The attorney-client privilege. And definitely it would assuage some concerns, for example, with exceptions, again, child abuse cases and mental health issues, for example. But because the same cases and the interpretation apply, we really need to look closely at the judicial interpretation, right? To make sure that we're not bringing with us interpretations that don't make sense or run counter to our goal. Like Dan was saying earlier about fraud exceptions, right?
Mm-hmm.
And on the broader space, how do we even deal with compliance and enforcement of the rule, right? How does that even look like? And at least that's where we're starting to think about it. I don't know if you have more
I am
comments, David. Yeah.
I'm so glad that you are thinking about this, and I'd like to bring in the rest of our group now so that we can talk about these issues among ourselves. And I'd like to start with a question for Rebecca. Rebecca, what can America and New York in particular learn from your experience dealing with these issues around the world about the medical record? What belongs in the medical record, what doesn't belong there, and what can be done to strengthen confidentiality? Oh, you're muted, Rebecca.
Okay, so my medical records are in my hands, and they're in Europe, and I just have them. And I was prosecuted also in Austria, from where I'm practicing, in 2009 on the request of the Irish government, and it was somebody that claimed to be a journalist, so I had to hand over those records as well, but it was not a client, so I didn't care. I think there's two things here. What I was thinking is you have to think. So there is, of course, the requirement to keep the medical records. My medical records are protected because the US is not going to get them, or any other country. But you can also think about it a different way. And that is that, for example, what we started doing is advanced provision, which means that people get the abortion pills before they're pregnant. Mm-hmm. That does not violate any law. So you could just put it, a doctor could just write down in the records preventive medication, and this is something that anybody could do. It wouldn't violate any criminal law. They wouldn't have to ask for it because, so that's one, the advanced provision. The other thing is where so that's it. Yeah.
So let me ask you a follow-up question to that. Do you have a sense, based on your experience, whether we in America ought to be considering moving, and I'm going to butcher the pronunciation, misoprostol and mifepristone, which I therefore refer to as M&M, to an over-the-counter basis, or some status less than requiring a full-blown prescription?
Yes.
And how do you feel about that clinically?
Well, clinically, it's totally safe. And actually, this is also one of the projects that I'm involved now. We are developing mifepristone in the lower doses as a contraceptive. And that is the idea, that we will have it available over the counter as well. Because it has the safety profile. As I said, it's safer than any of the painkillers. So there's no reason why it shouldn't be over the counter. The same thing with misprostol. It has very little contraindications. I would say none. But that is, of course, a political decision that is often based on medical scientific evidence. That's where it should go. And because in this way, then also the doctors cannot be held responsible anymore. Pharmacies cannot be held liable and responsible. So if you really want to, we need to say FDA for that. Yeah, that's what you said. I mean, even a move to try to get hormonal contraceptives available over the counter, that just failed. They were refusing to hear it. But we need a long breath. I mean, it took the anti-abortion groups 50 years to get where they are. And then that's like what we're looking at now as well, I think. If you look at reality, these judges are going to be there for the next 20 years. So let's brace and work for a 20-year but I think advanced provision is definitely a legal loophole here that should be used more and more. And you can do it with either prescribing misprostol or with mifepristone and misprostol. Because if somebody's not pregnant, there's no breaking of any laws.
And these are medications that have other indications, correct?
Yeah, They do, yeah. The thing is that, but also even for the treatment of an incomplete miscarriage, for example.
Mhm.
So a doctor could also decide not to write that it's for an abortion, but that it's for a miscarriage. Because it doesn't have any medical implications, because the treatment is the same,
Right.
he couldn't even be prosecuted for by a medical board for that.
Malpractice. Right.
Yeah. So I think that is the way medical providers have to start thinking, like how can they protect themselves, but also their patients. And instead of saying a woman comes for abortion, saying miscarriage management, period.
Mhm. Also, I understand for just an irregular period that there are medication indications on that basis.
Yeah, and actually mifepristone itself is also, but it's not registered for it. It's not regulated. It's not registered for that. So it's off-label use. But
Which
off-label use is allowed everywhere. It's not,
absolutely.
that is not against the law. So off-label use of this medication can also be used for regulating your period, misperiod pills, they call it now also. So there's a lot of space that
Mhm.
has to be carved out, that has to become more I would say explicit,
Yep.
and should be also should be educated to doctors and
And
lawyers to use
that could be
this.
part of your requirement for a clinician education, because clearly this represents part of the standard of care. So, Lynn, what do you think we should be doing going forward, given the discussion about medical record confidentiality and what belongs in a medical record that we've had today? What do you want people to be thinking about, both clinicians, lawyers, other advocates? Where does the patient's rights part of the conversation go next?
I think the patient's rights are that the doctor will never do harm.
Mhm.
And so when a doctor puts in their medical records that it's for an abortion, that might do harm in the future, so a doctor
Mhm.
cannot put it there.
Okay.
Uh,
Lynn, what do you think we do with this from an advocacy perspective, given what Rebecca has just shared with us?
From an advocacy perspective, what we're doing here, and I totally agree with Rebecca's suggestions. I mean, this comes up in a lot of places, the issues of pregnant women and drug use. Do you write in the records the patient's using drugs again, or do you write when it's a relapse, the patient exhibited the normal sequence of recovery? There are lots of ways of explaining things, and I think there may be more than that I haven't thought of yet, and maybe Rebecca hasn't yet, because I would just want to remind people that if the laws exist to protect unborn life, every pregnancy has a 15 to 25% chance of ending in miscarriage and stillbirth. By becoming pregnant, a woman is putting unborn life at risk. And so we have to have other ways of saying, assisted the woman in ensuring, her reproductive capacity or her reproductive health. There are lots of ways to provide the information you need for future health care for this woman without creating a path for criminalization and incrimination.
And
David, could I ask you a question, David?
please.
I know that a lot of the work that you do is advising clinicians in hospitals. You've been a general counsel of a hospital. You're involved with a number of hospitals now. And what do you do when a clinician comes to you and says, this young woman has come to me and she wants an abortion. Can I just put in my medical record that she had an irregular period? That's okay with you?
So what I tell
And
my
what about,
clinician,
excuse me, what about reimbursement rates and getting paid for services?
so what I tell my clinician clients is the same thing that I tell my law students, which is don't lie, don't cheat, but respect your obligation to your patient or to your legal client by doing what is in their best interest without regard to your interest in that privilege, whether attorney-client or physician-patient privilege. And frankly, when it comes to the indication for administration of a medication, as Rebecca said, you only need to record that which is clinically relevant. And Dan, as you said, the domicile of the patient is irrelevant and need not and should not be part of the medical documentation if it serves no purpose and presents a risk. As far as reimbursement is concerned, that's a whole bigger area of concern, in part because when a patient comes to a doctor for care, and that care is going to be reimbursed either by Medicaid, Medicare, or by commercial insurance, as part of that contract of insurance, the patient has consented to their medical records being supplied to the insurance company. And that's a concern we need to take very seriously. So maybe what needs to be done is we need to suggest or educate clinicians, and I think this goes back to Jorge's point as well, that they ought to seek reimbursement for whatever condition or portion of the patient's condition is appropriate for reimbursement that will not put the patient's freedom at jeopardy. So that's my answer. I also frequently remind my clinician clients that we're in the patient care business. We're not in the law enforcement business. And notwithstanding the situations that Lynn cataloged, clinicians ought not, normatively, as an ethical matter, to be engaged in law enforcement activities that are contrary to the interests of their patients. Lynn, you want to jump in on this?
I think Rebecca does. Go ahead.
Okay.
Yeah,
Rebecca?
yeah, because I think something about the reimbursement. I think this is something which, for me, also have been very upsetting about the US. These kind of treatments can really be much cheaper than they're charged for, and that is what we saw with telemedical abortions, where the rate for an abortion went down from $600 to $150. And so most people can afford to pay $150 out of pocket, and sometimes they can't, and if they can't, then you just don't take money. But the money should never be a reason why not to give. This discussion about money should not be in the way of what is medically, ethically correct to do. So that was my only remark. Thank you.
No, I think you're right, especially given the state of transition that we're currently in.
Exactly.
Dan, do you want to take Bruce's question?
Bruce.
I can do it.
In the chat? Bruce asks whether the laws that criminalize pregnancy, specifically in relation to abortion, can be attacked as being void for vagueness simply because the notion of what is an abortion and what is a miscarriage are medical terms not well defined in some of these laws. And by the way, for those seeking CLE credit, the second participation code is woman. So pregnant woman.
I saw Lynn chomping at the bit to address that question. Go with it, Lynn. I'll bet clean up.
Okay, please. Just to say two things. I want to acknowledge the existence of pregnant people. So that can be the third world, that people who do not identify as women are getting pregnant and are part, and all of their rights, bodily integrity, everything else are at risk from this Supreme Court. But to answer, void for vagueness is an excellent argument. And to the extent that any court has addressed the kinds of cases we've been working on for years, to the extent that they have addressed constitutional claims, the one claim they have acknowledged is, if you say risking harm to a fetus, it's so vague, it could include everything. And it is true that there's debate about what abortion is, although most statutes do define it, but it's a good one. Whether what we're going to accomplish through the courts remains a real question, as opposed to the political organizing that says, along the lines of what Dan said, the people who get pregnant are entitled to full constitutional and human rights, and that we have to be talking about that as loudly as we're talking about abortion specifically.
Well, thank you. And Dan, on the process of attacking these violations of patient privacy, do you think that this is something we should expect to be seeing more of, and that we should be preparing to take up those arguments?
Well, we might have expected in 2001, when Lynn won the Ferguson case, that patient privacy and the non-sharing of medical records with police for the purpose of prosecuting women wouldn't occur anymore. We'd think that that would have been resolved. We thought that some other issues in Roe v. Wade would be resolved as well, but we would be wrong about the confidentiality issues. We're going to see that more and more. I just finished a case in California, the Chelsea Becker case, a woman who went to the hospital, had a stillbirth, tested positive for methamphetamine, and was prosecuted for murder. And we wondered, well, how was it that the police were informed that she had a stillbirth at this hospital? And it turned out finally, only because a reporter thought to ask the question of the prosecutor, you know, where did this prosecution come from? He said, oh, we put together a task force with the hospital because we saw women getting pregnant and doing drugs at the same time, and we wanted to know which one of these people can we prosecute. So we put together a task force with the hospital, and they let us know when someone came in positive for drug use and there's a dead baby. And so those are the people that we prosecute. So, you know, that was the Ferguson case. And right. There it is going forward again.
And frankly, regardless how you feel about abortion access and abortion rights and personhood and parenthood rights, the right of confidentiality is foundational. And if we don't stand up to protect that right, again, notwithstanding one's views on abortion as a medical procedure or a moral question, then we have done damage, as Lynn pointed out, to more than just abortion access. We've done damage to our entire healthcare delivery system and the ethics that arise from it. Right. We have gone over 10 minutes. I thank you all. This has been just a terrific exploration and discussion. To those of us in our audience, if you're interested in these subjects, I urge you to reach out with any additional questions. You can go to Columbia Bioethics events to see the recordings of prior events that we've done on related subjects. Obviously, these issues are all addressed in our bioethics master's program and certificate program. But whatever you do and whatever your views are on abortion and the sanctity of medical confidentiality, I urge you to stay engaged on these issues. And thank you all. Good afternoon.